Welcome. My name is Sarah Harding. I'm the dean here at the law school. It's wonderful to see all of you here this evening. I'm going to say a few words about the Reed lecture, and then I'm actually going to introduce our hosts for the evening from CBC Ideas. Then I'm going to come back up and actually introduce our lecturer for the evening. So there'll be a little bit of up and down, but we'll get through it. It should be pretty smooth, I'm hoping. It is a great privilege to be able to sort of welcome all of you this evening to the annual Horace Reed Memorial Lecture. And of course, thank you to CBC Ideas for being here as well. It really helps elevate our event and certainly gets the wonderful ideas out there in the world. So let me start by saying, as I said, a few words about this lecture. The Reed Lecture Series was established to honor the memory of Horace Reed, an esteemed legal scholar and dedicated public servant who acted as dean of the law school from 1954 to 1964. Initiated as a collaborative effort between his family and the law school, the lecture commemorates a remarkable life marked by service, scholarship, and humanity. I want to add one little bit. There's a few more things I want to say, but I just learned upstairs that when he was dean here, he had a mission so that every law student who came through the law school, he taught at some point. So everybody who graduated was taught by him at one point in their 3 years here in the law school. So known for his contributions to the public through 2 world wars, his leadership in the legal community, and his benevolence and commitment to legal education, Horace Reed left a lasting legacy as a scholar, educator, and advocate. He received numerous honorary degrees throughout his career. The Reed Lecture series stands as a tribute to his notable contributions and enduring impact on the legal profession and society. We are really grateful as well this evening to have his son, Dr. Robert Reed, with us in attendance this evening. So let me say a few words now about our host this evening, Nahla Ayed, before turning things over to her. And then, as I said, I'll return to introduce Louise Arbour. Nahla Ayed is the host of CBC Radio's Ideas and a veteran of foreign reporting, first in the Middle East and later in London, where she covered many of the major stories of our time, including the rise of authoritarianism, the return of war to Europe, and the worldwide refugee crisis. Nahla's work has been recognized through numerous national and international awards and honorary degrees. She is the author of 2 books, both national bestsellers, and it's an honor to have her with us this evening, and CBC Ideas as well. So Nahla, I think, is going to talk to us a little bit about sort of the housekeeping and things like that before I come back.
Thank you. Thank you very much, Dean Harding. I'm going to keep this very short because we're all here to hear someone other than me. It's a real honor to be here for this occasion. We've been trying to do this for quite a few years. COVID got in the way. It's a pleasure to be here, and I know that Dean Harding says that our presence elevates the event, but truly this will elevate our content. So we're really grateful to be here. Thank you very much. Just a reminder that we are recording tonight's proceedings for Ideas. So I would ask, if you don't mind, just to make sure your phone is off, unless you want to make it to national radio, possibly international, and that you will have an opportunity to ask questions afterwards. I have about 100 questions I'd like to ask Madame Arbour, but of course I want to engage you as well. So prepare your questions. We have microphones. And now I'll give it back to Sarah Harding. Thank you very much.
Thank you. So really, it is truly a great pleasure to welcome Madame Arbour here this evening. Her work reflects a truly unwavering dedication to justice, human rights, and advocacy, and so we are truly fortunate and honored to hear her lecture today. So there's always a risk with someone such as Madame Arbour that the introduction will take more time than the actual lecture. Her remarkable career and accomplishments are hard to summarize in a short introduction. I promise to do my best here, not to take up all the time for the evening, but there are a lot of things that are worth pointing out right here at the beginning. So Madame Arbour earned her law degree from the Université de Montréal and began her career as a clerk for the Supreme Court and then as a research officer for the Law Reform Commission of Canada. She later became a professor at Osgoode Hall Law School, where she taught for many years. During this time, she published extensively on criminal procedure. We'll hear some of that in the lecture today, on human rights and civil liberties in both French and English, while also serving as vice president of the Canadian Civil Liberties Association. Her judicial career began with her appointment to the Ontario Supreme Court, and 3 years later, she was named to the Court of Appeal for Ontario. She also led an inquiry into events at the prison for women in Kingston. We just heard a marvelous story about it, which I will not, don't have the time to repeat, but that's a story that started off her time there in that inquiry. So she led this inquiry into events at the prison for women in Kingston, demonstrating her commitment to fairness and accountability. Madame Arbour took her dedication to justice to the international stage when she was appointed chief prosecutor for the UN's International Criminal Tribunals for the former Yugoslavia and Rwanda. She prosecuted some of the most significant cases of crimes against humanity, and in doing so, shaped international justice. As if her career could not be more distinguished, Madame Arbour was then appointed to the Supreme Court of Canada in 1999, where she continued to shape the landscape of Canadian law. After her tenure on the Supreme Court, she became the United Nations High Commissioner for Human Rights in 2004, and later served as president and CEO of the International Crisis Group, an international think tank that works to prevent wars and shape policies that will build a more peaceful world. She also undertook a critical review of harassment and sexual misconduct in Canada's armed forces, further again solidifying her role as a leader in systemic reform. Madame Arbour's contributions have been recognized globally. She has served as an ad hoc judge at the International Court of Justice, advised Canada on defense policy, and contributed to various organizations dedicated to justice and human rights, including the Global Commission on Drug Policy and the International Commission Against the Death Penalty. She is currently serving as a jurist in residence at the BLG law firm. Madame Arbour's extraordinary work has been recognized with over 30 honorary doctorates and countless prestigious awards, underscoring the significant impact she has had both nationally and internationally. This evening, Madame Arbour will address the thought-provoking topic, searching for the truth, just a small topic. The question she poses, is a criminal trial a search for the truth? Challenges us to explore the complex relationship between the structured rules of criminal trials and the evolving and increasingly contested concept of truth in today's world. Justice Arbour's insights on fact, evidence, and fairness offers a critical lens through which we can examine the role of truth in the overall pursuit of justice relative to our day-to-day lives. So with that, please join me in warmly welcoming Madame Louise Arbour.
Thank you very much. I will speak from my chair, as it doesn't seem to make any difference whether I'm standing up or sitting down in terms of my height and visibility, so I choose comfort. Thank you, Dean Harding, for this very warm welcome. I also want to thank President Brooks, former Dean Brooks of this law school. I feel very privileged to have an opportunity to come to Dalhousie. I have, even though I don't have immediate personal connection with this university, my daughter, son-in-law graduated from here, and my granddaughter is currently at King's College. So every opportunity for me to come and visit you is just great. I feel also very privileged to be included in the list of very distinguished speakers who have given this lecture in the past in honor of Horace Reed, a great academic and a great Canadian. And I have to say, although I'm very honored to be associated with such a legend in legal academic circles, I've actually been away from the academic world for a very long time, so I will speak to you today in a very different voice. As was mentioned by Sarah, I started my career, in fact, very much by accident in the academic world. I taught at Osgood for some 12 years, mostly criminal law procedure and evidence. And in fact, just to show you what a small world it is, any insight I ever had in the law of evidence I owe to Neil Brooks, Kim Brooks' father, whom I first met when we both overlapped at the Federal Law Reform Commission in the mid-70s. His work gave me my very first real glimpses of the complexities of this body of law, and also an introduction to the usefulness of asking not just what and how, but also why. When I was appointed to the High Court, now the Supreme Court of Justice of Ontario, I had never been to court, except for a brief appearance in the Ontario Court of Appeal as an intervener on behalf of the Canadian Civil Liberties Association in the Seaboyer case. That would be the subject of another very painful story altogether. So you can imagine the kind of learning curve I had to face sitting as a trial judge, presiding jury trials, loaded with academic insights, but barely knowing where to actually sit in the courtroom. I had absolutely no practical experience. You'll be pleased to know that I've blacked out most of the embarrassing episodes of my 2 years on the trial bench. But I remember to this day the most striking discovery that I made after a few months in my new job as a trial judge. It's all about the facts. In other words, after you have, quote, found the facts, most of the time the law just falls into place. After years of setting exams for law students, I felt I had it all backwards. Because as you know, in setting an exam, you typically give the students a set of facts from which you ask them to demonstrate their mastery of legal rules and principles. But it doesn't work like that in a courtroom. The process of attempting to reconstruct past events, quote, finding the facts or searching for the truth, has occupied a large place not only in my teaching law, including the law of evidence, but in much of the subsequent work that I did, and not only as a lawyer or a judge. So you will appreciate my dismay when I recently came across the 2024 report of an organization called Policy Horizons Canada. That report is entitled Disruptions on the Horizon. Policy Horizons describes itself as, and I quote, an organization within the federal public service that conducts strategic foresight on cross-cutting issues that inform public servants today about the possible public policy implications over the next 10 to 15 years. It's the Government of Canada's Centre of Excellence in Foresight. Our mandate, I quote them, is to empower the Government of Canada with a future-oriented mindset and outlook to strengthen decision-making. In my view, the author should have added a disclaimer warning that the content of the report could trigger some anxiety in those already concerned about the future and may therefore not be suitable for all audiences. The report examines some 35 possible events or circumstances in a variety of fields such as society, the economy, the environment, health, politics, geopolitics, and it ranks these events in terms of the combined likelihood of occurrence and severity of impact on how we will live over a 3, 5, 10, 15-year time frame. The report then lists the top 10 disruptions, that is, those that have the highest combined likelihood of occurrence and severity of impact over the shortest period of time. And the number one is, and I quote, "People cannot tell what is true and what is not. The information ecosystem is flooded with human and AI-generated content. Mis- and disinformation make it almost impossible to know what is fake and real. It is much harder to know what or who to trust." That's the finding of that think tank. Now, of course, other disruptions, such as the outbreak of a world war, would have much higher impact, but then are less likely to occur in the shorter term. But few would have such cross-cutting relevance to the development of appropriate policy responses as the blurring of true and false. At one level, this is not surprising. We're all aware of the extent to which inaccuracies, falsities, and lies have actually already invaded the public discourse in recent years. But the scope of the impact of this culture change is truly startling. Needless to say, this feeds into my lifelong professional preoccupation with the search for factual accuracy, both in justice and in public policy. I cannot canvass here the many legal areas in which this crippling inability to distinguish true from false could pervert our justice system. But think only of the task that we impose on our fellow citizens when we call on them to perform jury duty. If it's true that in their day-to-day lives, people will find it increasingly difficult to distinguish truth from falsehood, what does that imply for the guidance that we give them in a criminal trial, where they are tasked essentially to reconstruct past events, a process on which the liberty of the accused depends, and on which, frankly, in the long term, the credibility of the entire system resides. So this brings me to the so-called search for the truth in a criminal trial, and the apparently simple but often misunderstood rules that guide that process. So bear with me as we canvass a few of the fundamental rules that apply in a criminal trial. Through that exercise, we may get some insight into how we will overcome the deficit of trust that lays ahead for us, for all of us, in the years to come, if we are to believe the predictions of Horizons Canada. Outside the courtroom, we may actually need to reconstruct our intellectual and moral compasses to navigate this emerging reality, a reality that combines and at times confuses rationality, culture, trust, prejudices, moral integrity, personal interest, and much more. So too, actually, in a criminal trial. So the so-called search for the truth during a trial, it is deceivingly similar to the way in which we integrate the past in our day-to-day lives. Importantly, it is governed by the law of evidence, much of which is now anchored in the constitutional protections granted to persons charged with crimes in the Canadian Charter of Rights and Freedoms. So the law of evidence is the methodology applicable to the authoritative reconstruction of past events for the specific purpose of determining guilt or innocence. It is distinguishable from other scientific methods that may share the same interest in past events, such as psychiatry, journalism, or history. In a trial courtroom, an accurate reconstruction of the facts that are in issue is critical to a just disposition of the case. Well, that's not entirely true. A criminal trial is not a, quote, search for the truth in a philosophical or even in a scientific sense. It's a formal process through which the prosecution must prove what it alleges beyond a reasonable doubt. What it alleges often includes intangible things, such as the state of mind of the accused at the time of the events, what he knew, what he foresaw, what he intended. That exercise is rigorously governed by a set of rules designed in large part to discard irrelevant considerations and to guard against highly prejudicial ones, like biases and stereotypes that could infect the process and lead to a perverse outcome. In our system, many rules are poorly understood by the public, and they are actually rooted in the adversarial system, whereby the so-called search for the truth is largely in the hands of the parties, each one pulling in a different direction. Some rules, through which the evidence is excluded in a criminal trial, have nothing to do with the quality of the evidence that is cast aside. So if they seem to impede the search for the truth, these exclusionary rules serve a different, though related, purpose. So let's take the hearsay rule. Aside from its many exceptions, that rules, as law students will know, renders hearsay inadmissible in a criminal trial. Hearsay, for the purpose of that rule, is only prohibited when the impugned statement is offered for the truth of its content. Therefore, as again many law students will confirm, the rule is a little more complicated than its name suggests. It may consist of preventing a witness from saying, "I heard someone say something," but not always. If the only relevant purpose for the witness stating that she has heard that is in fact that she has heard it, whether it's true or not, then it's not precluded by the hearsay rule. For example, if an issue in the case is whether the witness was in a particular store on a given day and she's asked, "How can you be sure that you were in that store on that day?" She might say, "Well, I know that. I know that I went there because a friend of mine told me that there was a sale there on that day." Now, in that case, it doesn't matter whether there was a sale or not. So in that case, there's no violation of the hearsay rule. If, on the other hand, the issue at trial is whether the accused intentionally killed his mother, a witness cannot say, "The accused sister told me that he wanted to kill his entire family." Simple, you might think. Well, not always so. Most students will confirm that, because the rule makes no sense unless we understand its rationale. Hearsay is not intrinsically a bad thing. In fact, outside the courtroom, we constantly rely on hearsay, even to make decisions that are very important to us on critical issues. What matters is that we trust the person who relays the information, we trust its original source, and or we trust the process through which the information was acquired and conveyed. And our trust, of course, is a matter of degrees. For instance, when I ask to give my date of birth, what I relay is hearsay, even though obviously I was there. I also obviously have no personal recollection of the event. I simply trust what I was told, what has been recorded, and so do my interlocutors. Now, to a much lesser degree, we trust a news anchor who reports on events that took place at the other end of the world, about which she obviously has no personal knowledge. My point simply is that there's nothing intrinsically wrong with hearsay, except in the adversarial trial system, where hearsay deprives the opponent of the evidence of a full opportunity to test its reliability. This is the rationale for the rule, and the only way to understand why it stands in the way of the search for the truth. So the hearsay rule is a requirement of the adversarial system. That system assumes that the truth will emerge when each side has a fair opportunity to test and challenge the evidence presented by the other side. In the case of evidence presented by a witness, rather than, say, by documentary evidence, the opposing party has an opportunity to cross-examine the witness to probe the trustworthiness of his evidence. That, in turn, rests not only on the witness's sincerity, but also on the quality of his perception, recollection, and accuracy in recounting the facts that the witness claims to recall. If the witness testifies to events that someone else perceived, recollected, and conveyed to him, the cross-examiner cannot test directly the reliability of the original source of that information, therefore, allegedly, its truth. So it's only when hearsay is offered for the truth of the content of the hearsay statement that the adversarial system requires its exclusion, simply as a matter of fairness to the opponent of that evidence. And then, of course, there's many exceptions to the hearsay rule, and these exceptions, as you know, have evolved over time, mostly when there are strong indicia that the hearsay is actually reliable and that the opponent of the evidence is not unfairly deprived of an opportunity to test it by cross-examination. And I think the best example is if a witness testifies to what she claims the accused said to her, he, the accused, surely cannot complain about the lack of an opportunity to cross-examine himself. So, to cross-examine himself as to the truth of what he allegedly said on a prior occasion. But he, his lawyer most likely, can fully cross-examine the witness to try to establish that maybe the accused never said that, or that her recollection of what he said is faulty, about what exactly the accused said. So I'm going to resist here, even though I loved teaching hearsay when I was teaching evidence, embarking in an unending analysis of the hearsay rule and the rationale for its many exceptions. My simple point is that in a criminal trial, we often prevent the jury from accessing information that they would probably find interesting and useful. Take, for instance, also confessions, also often called self-incriminating statements, or criminal records, or more generally, bad previous misconduct. These are only introduced in a trial under very strict conditions designed to ensure that they're not given more weight than they deserve and that they don't unfairly prejudice the accused. Other disciplines, frankly, in fact, other legal systems, have no such concerns. From within their own scientific method and ethical rules, these concerns about fairness and prejudice may not be relevant. Again, the lawyers in the courtroom, those who've seen it, may share my discomfort with the movie Anatomy of a Fall, if you've seen it, because when I was watching it, I cringed at the way the accused was interrogated in court. It's fair to say that the continental system has its own logic and methodology and is very different from our own in that respect. The common law has long been preoccupied with confessions, more generally with self-incriminating statements made by a suspect or an accused before trial. Actually, confessions were once considered the only reliable evidence of guilt, and torture the only method of obtaining reliable confessions. Fortunately, in my view, we have come a long way since then on both counts. The Convention Against Torture prevents it absolutely in all circumstances, and the admissibility of a self-incriminating statements against an accused in a criminal case is subject to very strict requirements. To be admissible, a statement made by a person in authority, by a suspect, must have been made freely and voluntarily, free from threats or promises. And stricter rules even apply to statements, self-incriminating statements made by minors in light of their vulnerability. In fact, there's no question that it would be very difficult for an accused to contradict, even under oath, an admission of guilt he would have made to a person in authority during the investigation. Not surprisingly, many jurors would find it hard to believe that a person would confess to something they didn't do. So the law purports to guard against the highly prejudicial effect of a confession made in circumstances that may taint its reliability. This protection granted to the accused is embraced in the privilege against self-incrimination, which more broadly precludes an accused from being compelled to be a witness against himself. But the rationale for this, and for many other exclusionary rules, goes beyond strict reliability. In fact, it's best expressed, as you know, in Section 24 of the Canadian Charter of Rights and Freedoms, which provides that a court If a court concludes that evidence was obtained in a manner that infringes or denies any rights or freedoms guarantees in this charter, the evidence shall be excluded if it's established, having regard to all the circumstances, that the admission of it in the proceedings would bring the administration of justice into disrepute. So here, the, quote, search for the truth may have to yield to competing interests and values about the kind of society in which we want to live. Suffice it to say that a criminal trial, at least in common law jurisdictions, is not an open-ended search for the truth. The rules that govern that process are not solely concerned with relevance and reliability. They're also concerned with fairness. Fairness to the opponent of the evidence, who must be given a chance to challenge that evidence through cross-examination. Fairness to the accused, whose liberty is at stake and who faces the disproportionate powers of the state. Fairness to the jury, who must be sheltered from confusing irrelevancies and erroneous inferences. And increasingly, fairness to the victim, which was for a long time, I think, a concern that was mostly ignored. So I'm not suggesting that the laws governing the admissibility of evidence in a criminal trial should govern the way we navigate the dangerous environment in which we are increasingly unable, apparently, to distinguish between true and false. Nor should this be. It would be utterly impracticable and totally unnecessary. An ethical journalist would not publish a story she believes to be false, except, of course, to expose its falsity. But in terms of methodology, she would not shut out a hearsay statement. She would simply try to corroborate it. A psychiatrist will be interested in a patient confessing to a sordid crime, but not necessarily to validate its detailed accuracy, maybe more for the sentiments and the emotions with which it is recounted. Guilt, indifference, pleasure. In all these exercises, in the end, we're all engaged, professionally or personally, in our day-to-day life in the what happened for a variety of purposes, and we depend on our reconstruction of the past, the distant past and the more immediate past, for most of the decisions we make in our lives, big and small. I was always very conscious of having been conditioned by my interest in the law of evidence throughout my working life. Having been trained to believe that justice must be anchored in the highest possible attainable standard of accuracy in capturing reality, I often found it difficult to operate professionally in non-legal fields. Whether in my 5 years with International Crisis Group or in the various public policy and human rights issues with which I've been engaged, I always found it very difficult to shake the skepticism that I felt towards anything that did not satisfy me, at least on a balance of probability, but best beyond a reasonable doubt. Thankfully, you'll be pleased to know, I managed to escape the pathologies of skepticism that are rampant amongst conspiracy theorists, as I eventually succeeded in separating life from courtroom. Maybe for that reason, I am easily annoyed when I hear legal concepts used inappropriately, in my view, in day-to-day situations where they often seem to serve to confuse, rather than illuminate. Take the presumption of innocence. As a legal concept, it is the cornerstone of our criminal justice system, expressly provided for in Section 11D of the Charter, which reads, "Any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal." But like the hearsay rule, it has to be understood for what it is. And for that, I can do no better than to cite Herbert Packer's The Limits of the Criminal Sanction, in which, in my view, he brilliantly explains not only the what, but the why of that fundamental rule. And here's what he says. It's a long quote. "A murderer, for reasons best known to himself, chooses to shoot his victim in plain view of a large number of people. When the police arrive, he hands them his gun and he says, "I did it and I'm glad." His account of what happened is corroborated by several eyewitnesses. He's placed under arrest and led to jail. Under these circumstances, which may seem extreme, but which in fact characterize with rough accuracy the evidentiary situation in a large proportion of criminal cases, it would be plainly absurd to maintain that, more probably than not, the suspect did not commit the killing. But that is not what the presumption of innocence means. It means that until there has been an adjudication of guilt by an authority legally competent to make such an adjudication, the suspect is to be treated for reasons that have nothing whatsoever to do with the probable outcome of the case, as if his guilt was an open question. The presumption of innocence is a direction to officials about how they are to proceed, not a prediction of outcome. End of quote. Understood that way, the presumption of innocence serves as a rationale for the many rules and rights in our criminal justice system, like the right to a lawyer, the right to an interpreter, the right to be released from custody prior to trial. And it's also linked to another legal concept, often misused, the benefit of the doubt. Or put in other terms, the burden on the prosecution to prove guilt beyond a reasonable doubt. But like the hearsay rule, these ideas often make no sense in day-to-day life. For instance, if you want to hire a babysitter to look after your 3-year-old for the evening, and you hear from your neighbor that she heard that your proposed candidate is said to have smacked a little kid in the park the other day, you don't have to give the proposed babysitter the benefit of the doubt, and you're perfectly entitled to move to your next candidate. The presumption of innocence, as defined by Packer, has no application here. The babysitter is not on trial for assault, but if she was, she should get the benefit of the doubt, and the presumption of innocence would apply. And of course, you may very well choose not to jump to conclusion and to give her the benefit of the doubt. I wouldn't advise that. In the same way, when a candidate for an important public function, say for a US Supreme Court appointment, faces allegations of serious, possibly even criminal misconduct, these allegations should be examined diligently and certainly not dismissed out of hand on the basis of the presumption of innocence and the benefit of the doubt. It's hard to understand what the rationale for the presumption of innocence would be here. Even though he should be treated fairly, the candidate's not entitled to that job. His liberty is not at stake. Of course, if the same allegations were brought against him as criminal charges, he should benefit from both. We often say that it's better that 10 guilty persons go free rather than punish one innocent. But I don't see that it's better to put an unsuitable person in high office than to deny a candidate a job for which many others are perfectly qualified. So let me conclude briefly. I want to return to my original concern about our increasing inability to distinguish true and false. The search for the truth is becoming more elusive at a time where access to information is easier, wider, and faster than it's ever been. The deficit seems to be in the filters through which we access that information. The traditional filters, news media, scientific sources, political leaders, the so-called elites, have all been under attack and at times replaced by influencers who often have no other credentials than their popularity. So far, this cultural shift has not infected the uniquely designed process for reconstructing past events in the context of a criminal trial. But we may ask whether it could. Members of the jury no doubt import their own point of view, their experiences, assumptions, and beliefs to the task they are given. Could we one day be tempted to replace juries by artificial intelligence computations, which would then be trusted to distinguish between what is unlikely, what is probable, and what is certain. If so, we should remember that to sit in judgment of one's peers is not purely an intellectual exercise. It is a moral one, a process that should be guided by the very wise words of an old English case called Pierce versus Pierce. This is a case from 1846. I will quote from it, and you'll see from the language, it's very much from 1846, so bear with me. The discovery and vindication and establishment of truth are main purposes, certainly, of the existence of courts of justice. Still, for the obtaining of these objects, which, however valuable and important, cannot be usefully pursued without moderation, cannot be either usefully or creditably pursued unfairly or gained by unfair means, not every channel is or ought to be open to them. Here's the punchline. Truth, like all other good things, may be loved unwisely, may be pursued too keenly, may cost too much. So I invite you to reflect on whether other good things, like peace, equality, or freedom, may be loved unwisely, may be pursued too keenly, may cost too much, as I believe justice never should. Thank you very much for your attention. Look to her. Sorry, guys. I have to look this way.
We're trying to approximate a studio. Please forgive us. Thank you very much. Are you good, Jeff? Yeah? Does that sound okay? Thank you very much, Madame Arbour, for your comments. What a privilege it is to be sitting with you. And please forgive me for, at least for a short period, broadening the conversation beyond your comments and beyond Canada, in fact. And I thought perhaps I would start with writing that you've done previously, a lecture that you've given previously, similar to this one, but addressing the international context, in which you quoted Anne Michaels, a Canadian poet, saying that history is amoral. Events occurred, but memory is moral. What we consciously remember is what our conscience remembers. And I wondered if you could talk about the pitfalls of reconstructing truth in the context you just talked about, in this post-truth world, but at a time of really intractable international conflicts.
This question is so broad, I don't know
It is.
what angle I could take.
Whatever you like.
To try to answer it. I think one of the reasons we have so much difficulty finding common ground, and I'll say that very broadly,
Yes,
whether
please.
it's in some cases in interpersonal relationship, whether it's within a society, a culture that is actually quite cohesive, whether it's in a broader environment where positions clash, ideas, interests, for the most part, clash. I think it's in large part because of the take we have on the past and the way we see it. And well, I think we could even just think of very recent events, like American elections, for instance, a society that at one level is certainly much more cohesive than when it interacts with other parts of the world, but which, as we've seen, is extremely divided internally. I think a lot of the divisions are, it would seem almost irreconcilable because there's a profound disagreement on reality, a reality that is informed on the perception of relatively recent event, whether there was inflation last year, for instance, so the factual underpinning is experienced by people in such a different way, and then it becomes a reality about which they're not prepared to yield anything. It's their reality. It's what counts. So, the International Crisis Group, for instance, is, works in conflict, hopefully conflict prevention, but sort of conflict mitigation, conflict resolution, on a good day, conflict management. And I think at the heart of it is the starting point of the absence of a common ground and apprehension of what the past and therefore the present stands for.
A significant moment right now in international, the international legal system, with the arrest warrants against Putin, against Netanyahu, and members of Hamas. I wondered if we could speak a little bit about that. In the context of the body of the International Criminal Court, there have been a variety of responses to those arrest warrants, some saying they're symbolic, others saying, that they might act differently than what's expected. I wonder how you would describe this moment in the international legal system. Is it as symbolic? Is it as important as people say it is?
It is symbolic, but not only symbolic. It's real. Now, what will be made of it will depend on all kinds of circumstances, but it's not just a symbol. It's actually real. It comes from an international organization that has been created by states. They've undertaken obligations vis-a-vis each other. Unfortunately, states have undertaken lots of obligations vis-a-vis each other. I mentioned the Convention Against Torture. There are many where commitments have been made and not applied. It doesn't make it purely symbolic, right? These indictments are real. The arrest warrants have been issued are real from an organization that exists. Now, it's very difficult to predict what will then unfold. But let me just say a few things about the International Criminal Court that I think is often misunderstood. First of all, it's not a United Nations. The only justice instrument of the United Nations is the International Court of Justice, and it deals only with disputes between states. The International Criminal Court is a court created by treaty, the Treaty of Rome, where currently I think about 120 states are part of it out of 192 member states of the UN, and we all know all the big players in international conflict, the US, China, Russia, India, have not joined the court. In fact, African states and European kind of Western states have in large part ratified the treaty. The other thing that is often misunderstood is that court only has jurisdiction when the national court that would be involved, that is the court, say, where the crime occurred, fails to act. So it's subsidiary to national jurisdiction. So one of the ways that, for instance, Russia or Israel, for that matter, could block the jurisdiction of the court would be to investigate themselves the crimes that are alleged to have been committed. The court is secondary to credible national processes. Obviously, if the court came to the view that these are show trials, just set up to bypass the jurisdiction of the court, it presumably wouldn't abide by that. And people forget that. So it's a supranatural jurisdiction, international jurisdiction, but subsidiary to national courts. And then again, its capacity to act, its financing, and so on, all depends on contributions from states.
But knowing what you know about the court and looking forward, how realistic do you think is it that any of those people named would actually ever appear at the court?
Well, the one thing I could tell you is I issued an indictment against Slobodan Milosevic, and when I vividly remember when I gave a press conference and announced that I had charged him. At that time, my indictment was only for crimes against humanity and war crimes. I didn't believe then that we had enough evidence to charge with genocide. He was the strong man, still the president. At that time, he was the president of Serbia. There have been so many political changes. And a lot of journalists, I think, were very skeptical about whether he would ever be brought to justice. What can I say? I don't have a crystal ball. I told them, I don't know. I have a mandate, in my case, from the United Nations. These tribunals were created by the Security Council to investigate and indict those most responsible for the most serious crimes in the territory under my jurisdiction. That's what I did. The court, following my request, issued arrest warrants. I don't have a police force. I don't have any capacity to indict. But I can tell you, that's what I said at the time. If I did not believe that one day, under circumstances that are not apparent to me today, but that one day he would actually stand trial in The Hague, I wouldn't be wasting my time doing this work. It's not an exercise in symbolism. This is not theater. This is what I believe. Whether I'll be proven right or wrong, history will tell. And in what circumstances? One thing I was pretty sure was that what we had put in place elsewhere, that is, international teams actually effecting arrest, i.e. being parachuted in a country to pick up a suspect in the middle of the night and bring it to us in The Hague, I was pretty sure this would not happen to Milosevic. But what should have been quite predictable is exactly what happened. He lost power and his own people turned him over. That happens. So what will happen to existing warrants? The other thing I should say that is risky vis-a-vis these warrants is that we have never resolved the tension between justice and peace. When the International Criminal Court issued warrants against Joseph Kony, the Lord Resistance Army, it was seen as a potential impediment to peace, that he would never make peace if he felt that he would stand trial in The Hague and be imprisoned for life. And when I indicted Milosevic, there were lots of concerns amongst NATO leadership that he would never surrender. NATO was at war with him, and there were fears that, in fact, predictions that now he would have his back against the wall, would never surrender. Well, he surrendered a week later. But in the case of the existing ICC warrants, some politicians, not jurists, I think will be concerned that they are an irritant to any potential peace process, both in the case of Russia, Ukraine, and Israel and Palestine.
The last time we interacted actually through an intermediary, the big question that we were trying to answer actually addresses very much the point that you just raised, which is, how do you, in this world that we live in, and again, it's a very broad question, balance justice and peace in these really intractable conflicts that are going on? And with the old hat that you had on of the International Crisis Group, we spoke to mediators from Colombia, from Ireland, to talk about how do you invent peace in situations that are so intractable. So with that in mind, again, a massive question, given what's going on in the world right now, what is a way of inventing peace when you live in a post-truth world that is bitterly divided and is as conflicted as it is right now?
Well, I think the question I raised at the end of my talk is exactly on point. Justice, peace, freedom, all this can be pursued at too high a cost. It's very difficult, certainly for me at this stage of my career, to resist the idea that I should be very uncompromising. Militancy has a lot of appeal, but then it has to be, it's a choice one makes, but when you're a very committed militant, you just pursue your case and you leave it to others. It's a bit like the adversarial system, to make their case, and you don't feel the burden of compromising. But I think if you're involved in one way or the other, for instance, in a peace process, you have to ask yourself, can the pursuit of justice, i.e. accountability through criminal responsibility of political and military leaders, is that too high a price to save the human lives that would be saved if peace was put in place? It's a legitimate question. At the same time, peace also can be pursued too keenly and could come at too high a cost. I mean, peace, if it requires a complete surrender of any of your hopes and entitlements and subjugation to a foreign authoritarian force, that's too high a price. So I think that's an idea that one has to accept, that all good things may be pursued too keenly. Justice, i.e. with a confession obtained by torture, that's too high a price to obtain it. So I think that's, if one accepts that premise, then the question is, where can we find that consensus where both justice, peace, freedom, equality will yield a bit for something that accommodates the middle ground?
A couple more quick questions about the situation down south, and then I'll pass it on to the audience. One is the Supreme Court in the U.S., of course, we've all watched as it's become more politicized, more divided. Is there any reason for us to worry that something similar might happen in this context, in the Canadian context?
I think we should be concerned with everything we see happening everywhere in the world and not be so presumptuous as to think that somehow we're immune from these things. The Canadian process for the appointment of particularly Supreme Court of Canada justices is very bizarre. It would be completely unexportable. If a new country was setting up a constitutional framework, you don't think you would say to them, well, for your Supreme Court, which would have the constitutional powers to overturn legislation adopted by democratically elected members of parliament, that this Supreme Court, they should be appointed just by the Prime Minister. He should just decide who he wants to put there. You think, I don't think that's a good idea, right? And yet, that's our system, and I think it works, frankly, quite brilliantly. Speaking for my own appointment. But in a sense, this is also, it's kind of the tensions between kind of formal rules and culture. In a sense, the vast discretionary power, and I exaggerate when the Prime Minister just picks. I mean, we understand that there are informal processes in place of expected consultations and information. And in fact, in Canada, contrary to the US, the playing field is curtailed. In the US, if there's a vacancy on the Supreme Court, it could come from anywhere in the country. In Canada, there's already regional, well, 3 definitely have to come from Quebec, and there's the kind of constitutional convention, 2 from the West, 1 from the Maritimes, Ontario. So there's geographic, so it narrows the playing field. There's a long-term expectation that it mostly would come from appellate courts, sometimes occasionally directly from the bar. So, and then, we're still a relatively small country. Within these circles, people know who are the serious players, the good people. So we have a formal process that looks really bad, a lot of discretion in the hands of the Prime Minister, but in my view, that works really well. In fact, the worst thing we could do is to be hypnotized by the fact that the formal process not very good and start to try to imitate the US. Oh, we'll have Senate confirmation hearings. See what that looks like there? I think that it would be, there's the temptation to imitate something that looks good on paper but works terribly in reality, in my opinion, and yet ours is the opposite.
Could you comment on your thoughts on how nonlinear progress can be in people's rights when you look down south and you look at what happened with Roe v. Wade? Just your thoughts on the rights of women and progress where those rights are concerned.
Well, that's, on that, I have to say, I've changed my perception, and sometimes I wonder if I would have done the work I've done with the same faith in the future. Leonard Cohen said, "I've seen the future, brother, it is murder." I wish I'd paid attention when I first heard that, because now I think that's so true. For the longest time, I thought progress was linear. Progress in, the constitutional protection and the constitutional protection of minority rights in a democracy, the maturity of democracies, human rights, even to some extent, sort of more economic equality. All this seemed within reach. I mean, every step was moving in the right direction. And now I've persuaded myself that, in fact, it's not linear, it's cyclical. And all I can hope for is that we're at the bottom of the wave, that at some point it's going to swing back up. But for instance, on gender equality, everything I hear in the UN system is very alarming. It's terrible pushback taking place, even in just the drafting of very formal statements that are negotiated. All the language of gender equality is being pushed out very systematically. And in the same way, I never formally joined because of some conflict, but the Center for Reproductive Rights in the US. And I remember an occasion in which I said, maybe we shouldn't rock the boat too much, not kind of stir up that issue. And I remember this woman said to me, "Oh, make no mistake, they're stirring it up. So no, we should not be quiet. Nothing is safe. Nothing is granted." I thought this was very pessimistic and, in fact, quite alarmist. Well, now I realize how right she was. So I think we have to be very committed, very vigilant about some of the fundamental gains that I think as a society we've made and continue to work on these. But at the same time, certainly on the international scene, when I look at the international human rights agenda, there are many from non-Western countries, and I'll call it whatever you call it, the developing world broadly, that are now very overt about expressing their dismay that the promotion of our so-called values, funny enough, has always coincided with our interests. And I think there's a huge amount of suspicion vis-a-vis this kind of, post-Second World War intellectual and political dominance of Western value. And values are very dangerous. When I talk about searching for the common ground and compromising and so on, when people put their values on the table, it's the end of the conversation. They're not negotiable. And so we have to be very careful about advancing good things, but being attentive to others.
One last thing from me, which is, how did we arrive at a place in the West where a political leader of a democratic country could score political points by attacking the judiciary?
Oh, I don't think that's surprising. I don't think that's hard.
You don't see an increase in that in recent years?
I think there has been. Yeah. I mean, if we look at Mexico.
Brazil.
Yes.
And the States.
Well, yes.
Yeah.
There's something superficially attractive in the idea that people with power should be democratically selected. It seems it's one of these simple ideas. So judges, why should they have to decide they haven't been elected? But then, first of all, there are lots of judicial functions that are kind of neutral, or as one of my colleagues one time put it to me, don't be so obsessed about finding the right answer in this case. He said, the moral high ground is largely unoccupied. And I've had a lot of cases where I think that's true. The moral high ground was largely unoccupied. But in cases where, yes, they are fundamental issues, particularly on issues that are right but unpopular, why would you want judges elected? You already have the source of power, both in the legislative branch and in the executive, that are elected. Why should you have all the organs of governance subject to the will of the majority when, in fact, the majority has made a decision by giving itself constitutional constraints to constrain its own powers. So, but again, it's easily, because it's superficially attractive to say judges should be elected, it's not hard, I think, for politicians to do that. And I think what's really interesting is that certainly in Canada, I've been involved on issues where I'm pretty sure that popular opinion was not behind us in the court. Prisoners' right to vote, that's a case I had both when I was in the Court of Appeal and then in the Supreme Court of Canada. I think on balance, most people would have thought, no, they shouldn't vote. Capital punishment. I mean, the big trade-off was, in order to get rid of capital punishment, it's a mandatory life sentence with no eligibility for parole for at least 10 years, which we've seen very recently. It's very harsh in cases of so-called mercy killing. And we've made compromises, but what's quite extraordinary is that the public's confidence in the court, in our country, I think, in the courts and the Supreme Court of Canada, has not been eroded even in cases where, on balance, a majority of the public would not have been in favor of the decision. I think there's faith in the integrity of the process that we need to preserve.
Okay. I'd like to open it up for questions from all of you. Any of you? Just come up to the mic, actually. It's probably the best thing to do. Please go ahead. Oh, sorry, maybe not. Yeah.
Don't tell me you didn't hear anything I said. You're going to have to repeat.
Please go ahead. Yeah. Oh, just 1 second.
Right here. Hello. Thank you so much for taking the time to speak with us today. I'm curious what role you think principles or practices of restorative justice may have in resolving this issue of finding the truth in criminal trials.
That's in fact a really good example, I think, of essentially what I raised at the very end, which is that if it looks like it falls short of, say, accountability, it's not a bad thing. Only someone who would believe that justice, for instance, has to be pursued at any cost, only someone who would believe that, I think, would feel that other processes that are more consensual, in which there's a larger place for accommodating many interests, would reject that. So I think it fits in a much, much more sophisticated, common ground, consensual. A lot of good things are accomplished, but not one trumps all the other. Trumps. I hate that word. I can't even play cards anymore because of that. So there you have it. I think these are modern forms of appreciating the many ways in which we can accommodate so many conflicting interests.
Please, go ahead.
Oh, thank you. By the way, you stole my question. I have a slightly different opinion on restorative justice, and I was wondering if you could give me your opinion. To be parochial, it's Nova Scotia situation. Being a scholar, I'm going to be pedantic for a moment and say Alfred the Great said, "Doom the rich as you doom the poor. Doom the strong as you doom the weak. Doom evenly." And I don't see restorative justice with no judges, no transcripts, no evidence, no lawyers. The judge himself or herself is anonymous, and there are no court procedures. How can that be described as justice in any way? Thank you.
Well, that's your 2 points of view. I'm not very big on doom, so yeah, but you may also remember my great hero, only for that purpose, Lacordaire, who said, between the rich and the poor, between the master and the servant, between the strong and the weak, it is freedom that oppresses and the law that sets free. Good guy, Lacordaire. Yeah, but we don't own the concept of justice. You seem to be wedded to the idea that we have a process that we happen to call justice that has a lot of really good features. We're very comfortable with it. We know how it works. As I've indicated, we've developed very sophisticated rules that make sense, that govern all that. And we call that justice, and we preclude, it's just words. So if you don't like restorative justice, we could call it restorative processes. There are lots of ways of accomplishing if I use that terminology, maybe you'll reject it, the healing of the wounds that infect our present capacity to move forward together. Well, take for example, international criminal justice, the rationale for that. So when I was associated with the tribunals for former Yugoslavia, Rwanda, the theory behind that was that by all we could do, and it's been proven true now 20, 30 years later, by calling to account those most responsible, it would serve, in a sense, to exonerate the many, many others who were also guilty from the kind of collective guilt that they would otherwise carry. Like in Rwanda, to kill 800,000 people in 100 days takes a lot of hands. The tribunal has convicted, 50, 60, 80 people? But visiting criminal personal responsibility on political and military leaders allegedly would serve not to exonerate, but to preclude an entire, in that case, ethnic group, the Hutus, in perpetuity to bear the burden of their collective guilt. And is that justice? Well, some of the victims might say, I don't think so, didn't do anything for me. You know, the person who killed my entire family still lives in the same village. Was that not justice? Well, it was a form of justice. It was certainly better than any of the alternatives that could have been envisaged. So different processes, and as long as the parties interested in it come out of it feeling whole and feeling hopeful about turning a bit, you know, who am I to say this is not justice? I don't know. Not a justice with the mechanics that I'm familiar with, but it's not less so, I think. Yes.
Thank you for your comments and the talk earlier. In the very early days of the conflict between Israel and Hamas, the Jewish historian Yuval Noah Harari made the point that if you have to choose between justice and peace, you should choose peace. And I wondered, in the context of your remarks, whether you might offer some comments on that.
Well, first of all, I think his work is just fantastic. This is a fantastic reference, and especially his 21 Lessons for the 21st Century, I thought was a fantastic book. I don't think you can answer that in the abstract, whether, especially now, if you take the situation as it is now, it is posed very starkly. I mean, anybody who's going to try to be an honest broker of any kind of peace settlement is going to have to face very squarely that question. I mean, at the time of the tribunals that I was involved with, there was a very big movement. Emma Bonino from Italy was very engaged, the No Peace Without Justice movement, because at that time there had never been justice. Peace was always, you know, there was not even acknowledgement, recognition of the horrendous victimization of women, of all kinds of groups. Peace was to be pursued at any cost. The past had to be eradicated. So the No Peace Without Justice movement was very strong. Now, would one hold up the opportunity of a just peace, of a peace that is not perfect, but good, to stand for the accountability of some who bear such responsibility for, say, the way the hostilities were conducted? I think that question can only be answered in reality, not in the abstract, on a kind of, this is a very common law answer, I suppose, on a case-by-case basis, informed, I would hope, by this wisdom that all good things may be pursued too keenly, may come at too high a price.
Thank you for being here today. I'm just a second-year law student, so this is very illuminating. With that in mind, please bear with me during my chaotic question. In considering the pursuit of truth, I want to draw attention to the issue of self-represented litigants who are incapable of rooting their defense in reality due to mental illness. This issue was just heard last month by the Supreme Court of Canada, and we are awaiting a decision. The appellant's argument is that the test for fitness to stand trial needs to recognize individuals who are capable of meeting the fitness test, but unable to lead a meaningful defense rooted in reality. So with the discussion today, in response to the issue of people not knowing who or what to trust due to misinformation and disinformation, what is the truth, what is the reality we're living in, where do I anchor my beliefs? Given that this issue is currently facing the court in the realm of mental illness, do you think that our system is ready to take steps now for reform, whether it be criminal trial process, legislative reform, et cetera, or will it take the majority of society being affected, namely having the issue of truth substantially shaken, for meaningful reform to take place?
Only second year, huh? Good school. Well, first of all, I can't comment on a case pending before the Supreme Court, not just as a matter of principle, but because I have no idea about the case. This is not a case I have followed. But even if I had a lot of insights, I would let the process go through. I have no particular insight. I will just take your question more broadly. I have been, for a long time, an advocate of the need in Canada for a federal law reform commission. In my opinion, the one that I worked with in the early 70s, because I really believe the work that was done by the Law Reform Commission of Canada in the mid-70s informed the charter jurisprudence. I don't think we would have had the kinds of good early charter decisions had it not been for the work of the Law Reform Commission. I believe the Canadian Criminal Code is a mess. I believe that it's just unruly, criminal procedure. There are lots of court decisions about processes that need to be cleaned up. So I'm a very big fan of law reform. I know less, but I think in tax law, there's probably also a need for return to fundamental principles and kind of a restructuring of kind of fiscal management in Canada, but in criminal law reform. So what will it take? You seem to suggest that it would take something that would shake the majority's belief in the system. And it's true that criminal law is, people always seem to assume that it only happens to other people, very often not very good people, so we're not too concerned, but I believe we're long overdue for that and what it's going to take to make it happen. We cannot be of all good fights, but every time there's elections, I think we should vote for people who support ideas that we put forward collectively, and that's one that in the justice realm, which is rarely debated at the times of elections, you should be out there putting it forward.
Just a note on time, we have about 8 minutes left, so I think these 3 questions, and then that will be wrapped up for the evening. So please go ahead.
Thank you. Madame Arbour, since your report came out on sexual misconduct in the CAF, to what extent do you believe that the CAF has accepted your recommendations in good faith, and to what extent do you believe they've effectively begun to implement them?
One of the recommendations that I made that has been implemented is to ensure a follow-up to my recommendation is that the government should appoint I forget what I called it, like an external monitor of my recommendations. And someone has been appointed. I haven't followed everything that has been done since, but I know that mechanism is in place, and it was a woman, I forget who she was. I don't know if she's still the same one in place, but anyway, somebody is out there independently, supposedly monitoring and reporting annually on the progress on my recommendations. And I thought this was the very minimum I could do, not to guarantee or ensure, but at least to have a little bit of hope that it would not go, my recommendations, into the graveyard of recommendations. They had in CAF a huge board as big as this screen there with all the previous recommendations that had been made. I always referred to it as the graveyard of recommendations, and I could see my tombstone was already there. They only had to add the date. I was very concerned. They've introduced legislation to remove the jurisdiction of the military police and the military justice system in the case of sexual assaults, but it's may not get enacted before the next election. It doesn't seem that anybody's in a great hurry, certainly not internally in the CAF. So there's considerable encouragement in the appointment of Jenny Kerrigan as the chief of the defense staff. She was in charge of all this cultural reform in the CAF, and I think that's certainly a signal of maybe some commitment, but I hope others are following more closely than I am.
Good evening, Madam Arbour.
Yes, please, go ahead.
Thank you for being here. I'm going to ask you about something that has very little to do with the truth, but is rather entirely concerned with efficiency, but that's kind of the point. I think that with regards to the plea bargain system, the most generous interpretation would be that it promotes the effective administration of justice, whereas perhaps the most damning interpretation would be that it causes people, accused people, to admit to facts which don't reflect the reality, or even at worst, wash away a great deal of their criminality. But it is, in fact, essential to the functioning of the criminal justice system. My question is if you feel that the benefit is worth the cost.
In the current environment, I'd say yes, but I would add very unfortunately so, which is why I would hope that a serious criminal law reform exercise would look at the inefficiencies in the system that make it imperative to get rid of 90% of the cases. One has to ask ourselves, why is it that we can't function without kind of getting rid of 90% of the cases through plea bargaining, the result of which accommodates the immediate interest of the parties, not always the public interest, and is essentially based on a false narrative. In a lot of, sometimes it gets it right because the prosecution overcharged in the first place, but in a lot of cases, the narrative on which it's based is essentially a fiction that tries to accommodate the fact that this system cannot deliver.
And the final question.
Thank you, Madame Arbour. You mentioned that in the UN system, there is terrible pushback against gender equality at the moment, and that all the language of gender equality is being pushed out systematically. I'm wondering if you can provide some insight into why this might be happening and the reasons as they relate to the search for truth. Specifically, are disagreements about reality between people who are unwilling to prepare or who are unprepared to give up anything and who disagree about the applicable interests and values and even the words and concepts that they use, causing policy and lawmakers to distance themselves from issues pertaining to women's rights?
I'm not sure I could do justice to the full scope of your question. I could certainly on the first part as to what's happening, I think, internationally and why. In the UN, well, certainly in a lot of environments, we're looking, for instance, for some kind of equitable access to jobs. Let's put it this way. In the UN, there is a formal requirement of what it's called, in terms of UN posts, equitable geographic distribution. It's very formal. You can't have, the Office of the High Commissioner for Human Rights or UNHCR, any office cannot be staffed only with Americans or Germans or South Africans. There's a requirement of equitable geographic distribution, and it's very formal. And as a result of that, the UN, all the UN agencies, funds, and programs are very diverse, ethnically diverse, which is great. There's no equivalent requirement of gender equality in the rules, as a result of which it's been a real battle to get women in high office. The same you see in the corporate world and so on. There's been an increased effort by especially the current Secretary General, who was determined all the appointments that were directly his prerogative. He ensured that there was at least 50% women who were appointed, but the pushback, so for a while, it looked like we were on course. It's not a formal requirement like geography is, but there was, an increase, like in other spheres of society. Now, the pushback against gender equality, I think, is part of the larger pushback against all things Western. It's part of the kind of the rise against the hegemony, the dominance of so-called Western values, which, as I said, are perceived as having served mostly Western interests. I think it's part of that package, and it's almost the flagship of the pushback against a dominance of Western ideas and Western dominance.
I have a fun one.
A quick fun one, because we literally have 1 minute left.
Yep. Expert in procedure and evidence, 12 Angry Men, Henry Fonda or Eli Wallach?
Well, fortunately, it's not 12 Angry Men anymore, fortunately. It was, you may be pleased to know, not pleased to know, but surprised to know that when I was in law school in Montreal, women were not eligible to serve as jurors. They were eligible for judicial appointment. In fact, there were 1 or 2 women judges, but you couldn't serve on the jury. And I like to think that they're less angry now, but there you go.
Eli was a little on the myth side.
Thank you very much for your questions, and thank you, Madame Arbour, for taking our questions. I look forward to our more fulsome conversation in the weeks to come. Thank you. And back to Sarah.
Be brief. So first, thank you so much, Nala, for leading that discussion. It was truly brilliant, so thank you. And to Madame Arbour, we just had decades of your experience and your wisdom shared with us here in the room, and I feel at the very least incredibly grateful for all of that, and for all of the breadth is really, I guess, the word I'm looking for, just the breadth of your wisdom across the years and across so many different areas of law and across both the international and the domestic context. So thank you so much, and a little something for you. And thank you, everybody, for coming.